Our last case for today is People versus Langston. Good afternoon. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive and may want to waive. And you may reserve time for rebuttal, but we ask that you keep track of your own time, and you can begin when you're ready. And everyone knows how they're splitting up time, 15 minutes, and you've got it worked out?
Yes.
Mr. Rastusha? Hold on one second. You're good. You understand the split, and you guys have that handled? Okay.
Yes.
Okay.
I'm gonna reserve 6 minutes for Ms. Zimbelman and try to reserve 2 minutes for rebuttal.
Okay.
Of the 15.
Okay, great.
Good afternoon, Madam Chief Justice. May it please the court. My name is Mira Edmonds from the University of Michigan Law School for Mr. Edwin Langston. This court should hold that the Aaron rule applies to Mr. Langston and all other defendants who were convicted before Aaron without a jury finding of intent to commit murder, or at least those like Mr. Langston whose cases were on direct appeal at the time that Aaron was decided. There are multiple paths open to the court, any of which lead to relief for Mr. Langston. First, because the Aaron court interpreted the meaning of Michigan's first-degree murder statute under basic canons of statutory interpretation, this court should hold that the Aaron rule applies to Mr. Langston without needing to engage in retroactivity analysis. Alternatively, this court should find that the due process violation left undecided by the Aaron court dictates vacating Mr. Langston's conviction. Finally, if the court finds that Aaron announced a new rule, that rule is manifestly substantive, as the state concedes, and under both federal and state law must be applied retroactively. I waive the remainder of my free fire time and welcome the court's questions at any point. Just grab some water. Easy to pour.
Turn it.
Turn.
Twist it.
Thank you. When the Aaron court held that there cannot be a conviction for felony murder without a jury finding of intent to commit murder, and that the statute merely serves to elevate a murder from second degree to first degree based on the existence of an underlying felony, it was engaged in statutory interpretation, that it declared what the first degree murder statute means and has always meant. Contrary to the suggestion of the state and its amici that this was a legislative act, the court didn't change the language of the statute. It only made clear what our understanding of its meaning should be.
Counsel, how do we, let's assume even, I agree with you, that the court should have decided this differently in the past. How do we, or that Aaron should have been decided differently. How do we resolve the application to the defendant here? We've got this law of the case thing, we've got res judicata. How do we get around that?
Yes, so in this case, Mr. Langston's case was on direct appeal at the time that Aaron was decided, along with about 30 other defendants. And it's really happenstance, as is actually stated in Justice Levin's dissent in Lunchar, and is also referenced in the dissent in Mr. Langston's case. It's just happenstance that those 3 defendants whose cases were heard together in Aaron, and in fact, one other case, Wilder, that they received relief, and that the other defendants who raised the same claim, whose cases were on appeal at the same time, did not receive that relief. So that's the sort of arbitrary line drawing that really should not be employed. Again, going back to Justice Harlan's argument about the purpose of judicial review, at the very least, a decision of this nature should be applied to other defendants that are similarly situated. And again, Mr. Langston was on direct appeal at the time, but whether this court considers it a matter of statutory interpretation or decides to address the due process issue or considers this a new rule, it's a substantive new rule, again, as the state concedes, under any of those frameworks, it really should also apply to individuals whose convictions were final. Again, if the court decides that Aaron announced a new rule, and our position is that it was a matter of statutory interpretation, there was no new rule. But if the court decides that it was a new rule and decides to engage in retroactivity analysis, it should apply Aaron retroactively to Mr. Langston and those like him, because the rule involves substantive rights of a fundamental nature. Again, going back to this court's articulation in Gay. Conclusion is the same under the federal standard articulated in Teagan and Montgomery. And the Aaron rule is clearly substantive. Again, there's not really a dispute about this, but it clearly narrows the scope of a criminal statute by interpreting its terms, as the Supreme Court said in Shrivo v. Summerlin, and more generally as a rule forbidding criminal punishment of certain primary conduct, as stated in Montgomery. Aaron made clear what is within the scope of first-degree felony murder and what is not. What is not is killing in the course of enumerated felonies that occur without any proven mens rea with respect to the killing. And again, the state concedes this in their reply to the CDAM brief, that the rule is substantive. Just last term in Schaefer, this court noted that the usual retroactive application is applied to cases before the court and all cases that could have and did raise the issue that are pending at the time of the decision. That's Mr. Langston's case at the time of Aaron. And again, if the court chooses to look at the due process violation under Ivan v. City of New York or Hankerson v. North Carolina, this is a due process violation should be applied. That rule should be applied retroactively as well. If I could address the arguments in the state's brief that this is somehow a matter of common law and that that's different. In the first instance, there is only statutory murder in the state of Michigan. If a person is charged with murder, they are charged under the statute, either the first degree statute or the second degree statute. There's no such thing as a charge of common law murder. We look to the common law to understand what murder means. And so when the Aaron court was interpreting the statute, they were looking to the common law to understand what murder means, but it was not a matter of common law. It was a matter of statutory interpretation. Even so, there's no authority for the idea that there's somehow common law carve out from retroactivity. The same rules of retroactivity would apply even in that instance. In fact, in Linkletter, the court actually said in that case that the default rule of retroactive application for statutory interpretation or common law should also be applied to constitutional rules. In other words, the retroactivity in the context of common law wasn't even in question.
Is it your position that we need to overrule Hall for you to succeed?
It is not our position that you need to overrule Hall. Ms. Zimbelman can address that at greater length, but we think that you could make a carve out for Mr. Langston for individuals who were convicted of felony murder without a finding of malice, without a mens rea finding, without necessarily overruling Hall.
Okay.
What is your response to the arguments that there actually was malice in this case and that it's therefore not a good vehicle to address this issue?
So the state's position seems to be that there's some evidence of malice, certainly not overwhelming, but the important thing is that there was never a jury finding of malice. The jury was not properly instructed on that point. And so the question is whether there's a jury finding. There is not whether there is a possibility that a jury could have possibly, under some other circumstances, found malice. I'll reserve the rest of my time. Thank you.
Good afternoon, Your Honors. Jessica Zimbelman from the State Appellate Defender Office on behalf of Amicus Criminal Defense Attorneys of Michigan, and I'm joined by my co-counsel on this amicus brief, Ryan Keast, also an assistant defender with the State Appellate Defender Office. This court should hold today that it is unconstitutional, cruel, or unusual punishment to mandatorily sentence a person to die in prison when a fact founder has not found them guilty beyond a reasonable doubt of murder. That's what happened to Mr. Langston and people like him. And this court should also overrule Hall, although they do not need to in order to find relief for this group of folks. Because what we're talking about here is the sentence imposed on a subset of people who were convicted of felony murder pre-Aaron. And that's like what this court did in Lyman, where it found SORA registration unconstitutional, cruel, or unusual punishment for a certain group of people. That's what we're asking for here today. Cruel or unusual punishment for people convicted of felony murder pre-Aaron. Justice Welch, you asked in the Zarnecki argument whether our evolving standards or standards that have changed is relevant to whether Hall should continue to be upheld. And this court should consider that. In Parks, this court said that evolving standards of decency mark the progress of a maturing society. The Hall decision was issued 49 years ago. And to say that our standards of decency have changed in the last 5 decades is an understatement. 50 years ago, the state could kill children. It wasn't until 2005 that the United States Supreme Court issued their decision in Rober. 50 years ago, we could execute people with mental challenges. Atkins wasn't decided until 2002, and we can't even use some of the language that was used in that opinion in Atkins. And of course, 50 years ago, 18-year-olds, 17-year-olds in Michigan could be sentenced to die automatically in prison. And of bearing here, Hall was actually decided before Aaron. So it wasn't even clear at the time Hall was decided how a person could be guilty of felony murder. And when you look again at the evolving standards of decency, our brief, the CDM amicus brief, talks about the racial disparities with felony murder sentences. Of the folks right now who are currently identified on the list of pre-Aaron people convicted of felony murder, 82% of those people are Black. And we cannot, as a society, uphold a doctrine that imposes unusual punishment for one group of people, one group of marginalized people. That does not comport with our modern standards of decency, and that is what guides this court's constitutional analysis under our cruel or unusual punishment clause. And getting briefly into the Lorenzen factors about the cruelty and the unusualness of this sentence, again, for people who were not found guilty to beyond a reasonable doubt of having the required mens rea of murder. The first factor in the Lorenzen analysis talks about the severity of the offense versus the gravity of the punishment. This court said in Parks that murder is a heinous crime. We all know that. We don't have to discuss that. But what's relevant here is that Mr. Langston and other people like him were imposed a death in prison sentence, which is the harshest sentence in this state, without being found guilty of committing that most heinous offense. We reserve the harshest penalty for the worst, quote-unquote, offenders and crimes. But no jury has found that here. And going to this court's opinion in Lyman, that to have a constitutionally proportionate sentence, the punishment must be tailored to a person's personal responsibility and moral guilt. And for these people who were sentenced 45 years ago now to die in prison without a finding that they are in fact personally responsible or morally guilty offends our Constitution and is unconstitutional. And if the court has no questions, I'm going to save the rest of my time for rebuttal.
Thank you.
Thank you.
May it please the court, Eric Rastusha from the Attorney General's Office, appearing on behalf of the people and the Van Buren County Prosecutor. With me at council table is the Dean of the Appellate Prosecutors, Tim Boffman, who will be arguing for 5 minutes on behalf of Pam, and I'll be managing the time. Thank you, Chief. There's two central points I'd like to make this afternoon. First, this court in Aaron made a change to the common law in 1980 in removing what was the fourth category of malice, eliminating the ability of the people to prove felony murder by proving the intent to commit the underlying felony. Contrary to the arguments of Mr. Langston, it was not an interpretation of what the statute meant all along. Langston's claim that there was a due process error is predicated on his misunderstanding of the nature of the ruling in Aaron. Langston was properly convicted of felony murder under the old common law in 1976. There were no error in the instructions. As to a change in the common law, which this court enacted in 1980, it was like a legislative amendment to the law. There was no requirement for this court to make that change retroactive. And the idea of revisiting the policy decision to apply Aaron only prospectively, more than 40 years later, would be unprecedented. If stare decisis does not apply here, it's hard to think when it would apply. His conviction should stand. Second, the real argument here is about the fairness of his sentencing based on a claim that it's cruel or unusual punishment. But that claim also fails. As the Court of Appeals noted in 1978, in Mr. Langston's case on direct review, there was sufficient evidence presented at the trial from which a trier of fact could have found malice based on the definition from Aaron. So this is not a circumstance in which we have a criminal offender who is serving a life sentence when there's no evidence of malice, as defined by Aaron. Langston is like many of the other post-Aaron offenders who are serving a mandatory life sentence. As this court explained in Hall, his relief should come from either the governor or the legislature. And I have one further point I'd like to make in kind of the introductory comments. That's about Langston, the person who was the shooter here, Ronald Wilson, and the other pre-Aaron offenders. If this court were inclined to grant relief to Mr. Langston on his sentencing claim, because the jury did not make a finding of malice under Aaron, this relief should not extend to other offenders like the principal offender here, Ronald Wilson, who was 27 years old, for whom there was overwhelming evidence of malice, as currently defined, when he shot Oretta Ingram in the heart. And if you look at the other offenders in this pre-Aaron cohort, there are some offenders whose crimes are of the gravest nature. Consider Gary Gilmore, notorious kidnapping and brutal execution of two small boys who were abducted out of northwest Detroit more than 50 years ago in 1973, or Fletcher Small, the youngest of these offenders, who was convicted of, with others, the rape, torture, and murder of an 86-year-old woman. This cohort of 105 offenders are not all similarly positioned. So if this court, I don't think Mr. Langston is entitled to relief, but if this court were inclined to grant relief, among this 105, there are some for whom the evidence of malice was overwhelming. And if the court had granted relief in 1982 to those offenders, based on a finding that Aaron should be applied retroactively, they would have been reconvicted and they would have been serving a life without parole sentence under current law. So the idea of coming back 40 years later and revisiting the retroactivity of...
So how do we do that, though? I guess I'm confused. I mean, understanding that you don't think that Mr. Langston should receive relief here, how do we make that carve out?
So it seems to me that the claim under the conviction, it's based on a misunderstanding of Aaron. So if we're talking about sentencing, all right, so we're going to say it's cruel or unusual punishment to allow a conviction to enter where there was no finding of malice under Aaron. And the question is, well, how do we say, Mr. Langston, you're here, and Mr. Wilson, you're over here? Well, the question of whether it's cruel or unusual punishment, I mean, the ordinary standard is it punishment or is it cruel or unusual with respect to you? Now, part of the posture of this has to do with the claim that Aaron should have been applied retroactively, and so the cases that are pending on direct review should have gotten relief, or maybe even those cases that are closed on direct review. But the point, though, is that in many of those cases, the evidence of malice was overwhelming, right? For Mr. Gilmore, the claim wouldn't be, I didn't act with malice when two young boys are, executed. The claim would have been, I didn't do it, right? It would have been a claim of innocence. So what this court does in its cruel or unusual punishment analysis, if it doesn't accept this idea that, Hall provided, which is you leave it to clemency, you leave it to the governor, this court then comes in and says, where, as here for Mr. Langston, the evidence of malice was not overwhelming, was not clear, I think probably would be the better description, it would be cruel or unusual punishment. But I think that kind of caveat is essential.
There's no jury finding of malice? Is that sufficient?
No, because if there is an improper instruction, let me restate that. There was no improper instruction. Before 1980, the rule was if you commit the underlying felony, that's sufficient. And the Aaron opinion is unambiguous. I mean, I think that's worth reiterating since the point's been pressed that this was a statutory construction. The change, it was not. What the court said is the common law defined the elements of murder, and the question was for the court whether it was going to allow the continued existence. The question of whether we should continue to recognize the common law rule which allows the mental element of murder to be satisfied by the proof of the intention to commit the underlying felony. In other words, these offenders were all correctly convicted under Michigan law as it existed before 1980. So the question comes in, well, we think the common law shouldn't have been that way. But it was that way. But we don't like it now because we're afraid that we have then people sitting where there was no jury finding of malice. That's the concern. So the question then comes is the prosecutors didn't have an opportunity to come back in. The people, it's really the people didn't have an opportunity to come in and re-prosecute those people because this decision is being applied 40 years after the fact. So I think it's perfectly fair if the court's doing a cruel or unusual punishment analysis. I mean, I think Hall should govern. But if you're going to say, no, we're going to create this, a carve-out for these offenders, it should be clear that it's only cruel or unusual punishment where there's insufficient evidence of malice that was presented at the trial itself. It would be a fact-sensitive inquiry. But, I don't think Mr. Small doesn't get resentenced when his crime was he and 3 other men brutally raped over 4 hours an 86-year-old woman, right? I mean, it's the crime, it's the kind of, and within this 105, there are others like Mr. Langston. I'm not suggesting that they're all heinous, but there are some offenders in there where it takes your breath away. I can't even give you the full facts of the Fletcher Small case because they are so horrific. And the idea that because, I think in Small, the Court of Appeals said he did get an instruction consistent with Aaron, which, obviously they had 2 sets of Court of Appeals decisions that were in play from 1976 on. Nonetheless, the point, though, is still the same, that for a cruel, unusual punishment, the analysis would be where the evidence of malice was not clear. Because in some of those cases, because that wasn't the standard under the pre-1980 law was if you committed the underlying felony, that's malice. So malice was established under the existing law at the time. The court said we can't have it that way. It's not the right standard to equate the intent to commit the underlying felony with these other 3. And going forward, this will be the rule.
So just practically speaking, how would this work? Just practically speaking.
All right, so if you think Mr. Langston, I agree, it's not like, oh boy.
No. Let's assume that this court says, okay, we'll take that proposal, and when we do, we do a carve out, and there's this malice piece to it.
Right.
Okay.
So,
then it goes back. Then what?
Well,
So
and
is everybody is resentenced?
No. So I think it would be like this. In fact, you have in a way two different defendants before you. One was charged. Was prosecuted separately, but you have essentially the postures of each of the cases. You have Mr. Wilson and you have Mr. Langston. Mr. Wilson shoots the woman in the heart, right? She's unarmed. The suggestion that there wasn't sufficient evidence of malice for Mr. Wilson's conviction, assuming the evidence came in like it did against Mr. Langston, it's very weak. It seems to me that this court could say, for Mr. Langston, the evidence of malice was not overwhelming. He's entitled to resentencing as cruel or unusual punishment in this posture since there was no jury determination. For Mr. Wilson, he gets no relief because he was the principal and the evidence. Now, I'm assuming that the factual records are identical, but they're, obviously they're different trials, but, they occurred at the same time.
So is it like an aid or a better analysis? Somebody
No,
who's
it
aiding
has
and
to do with-
abetting is different than someone who's pulling the trigger?
No, it has to do with the evidence of malice because, you think about the 4 offenders who raped an 86-year-old woman over a 4-hour period of time. It seems to me that the idea of one's aiding and abetting, one's a principal, who's the aider and abetter? The evidence of malice there is going to be overwhelming under Aaron. And those guys...
Just by virtue of the crime itself?
Because of the evidence that was presented at trial. The question would be, let's say this, it's almost like an instructional error claim. Sometimes there's a claim that you didn't get a proper instruction, but the evidence of that element was overwhelming, and so there would be no prejudice in any event. That similar kind of analysis could be applied, it seems to me, in the cruel or unusual punishment context.
So help me figure this out. So that would be a decision to be made by the trial court of whether there was sufficient evidence. What's the standard of proof of sufficient evidence, and what's the review of the court's decision of looking at whether or not there is sufficient evidence of malice such that he doesn't fall in the category of that?
And before you answer, you have 4.5 minutes.
I know, I
left.
saw that.
Okay.
I was thinking, because let me answer this question and then give Mr. Boffman the chance to come in behind, and I want to give him some time to. But it seems to me it's the defendant's burden to carry, and it seems to me that the claim would be that in a way, we're kind of in an analogous circumstance. So I had come in thinking clear and convincing that you would have to, once placed in an issue, it would be a preponderance standard to show that there was not clear and convincing evidence of malice. So I was thinking clear and convincing evidence of malice, that kind of concept. Like, Mr. Wilson, it's clear. For Mr. Langston, it's not. And it would be ultimately the burden of the defendant to show that it had no bearing on the verdict.
Sounds like a lot of things to be worked out
Well,
beyond this case, right?
well,
I
but
mean,
it seems to me
haven't-
it seems to me the court could be more limited, but says in this circumstance where here the evidence of malice is equivocal, he's entitled to relief, leaving for another day Mr. Wilson and the other more aggravated offenders among this cohort. But my point to you is if the court is inclined to grant relief, I don't think you should be painting with this huge brush about these 105 people. It should be very narrowly viewed and leaving for those other offenders attempt to come in, because there are some people who are not entitled to relief. They shouldn't get resentencing. They should get nothing. They are some of the worst offenders.
Thank you.
But I'll leave it for Mr. Boffman to come in. Thank you.
Good afternoon again. Tim Boffman representing Pam, arguing as amicus in this case. In People v. Perkins, Justice Kelly wrote for a unanimous court that when the legislature codifies a common law crime, without articulating its elements, the court must look to the common law for the definition of the crime and I'm quoting, is bound by the common law definition until the legislature modifies it. The court said essentially the same thing in cases such as Couch, Reeves, and Riddle. Murder has been a statutory crime in Michigan, adopting just that common law term murder since 1837, when at that time it was punishable by death. When Aaron was decided, this court did not have that understanding, had not come to that understanding, and believed it could expand or contract common law terms used in statutes. One of our greatest justices, Justice Ryan, wrote an opinion abolishing the common law year-and-a-day rule. This is a case the prosecution won, and I think won wrongly, because Justice Ryan believed and said that if common law crimes could only be contracted, not expanded, this would tend to slow needed development of the common law, since once the definition of a crime was narrowed, as in Aaron, and I'm quoting, the court would lack the power to reverse itself and expand liability by readopting, for example, the felony murder rule. But the court now understands and recognizes there are no common law crimes. There are only statutory crimes that use common law terms without specification, alteration, or amendment. In Aaron and in Stevenson, the court did not interpret the murder statutes by altering the common law understanding. It changed them. It amended them. The court did not say what the law is. The court said what it shall be, which is not a judicial function. The court acted legislatively in Aaron. This court said in Aaron, and has said repeatedly since, that it was abrogating the common law fourth way of proving malice. And I think the court understood implicitly that that's what it was doing. It was amending the law, and that's why it applied the law prospectively. All the prior convictions were valid convictions. They were decided under the substantive law that existed at the time. The court changed the substantive law. Now, it shouldn't have done so, but it did. In my view, Aaron was wrongly decided on the merits, but correctly decided because of the way it was decided on the merits, but correctly decided with regard to prospectivity. We are content if you leave Aaron alone and don't revisit the prospectivity ruling, which we believe was correct given the way Aaron was decided. But if the court's going to reconsider the application of Aaron prospectively, it ought to reconsider Aaron, because Aaron, for the reasons I stated, overstepped its bounds. Now again, we're content 44 years later under the rules of stare decisis to leave it alone. But that also means we should leave alone the application of Aaron. The convictions were valid convictions. If there are no questions, thank you very much.
Thank you. We have 2 minutes, and I think you know what we want to know, right? What's your response to a carve-out that makes it very clear that the offense, malice was not proven?
That is a completely unworkable rule and not at all consistent with this court's cruel or unusual punishment jurisprudence or sentencing jurisprudence. Essentially, what the prosecutor is asking this court to do is do a sufficiency analysis before determining the constitutionality of a sentence. That is not workable, as evidenced even by their standard mixing two, that it would be the defense's burden by a preponderance to show by clear and convincing evidence that there wasn't malice. That is unworkable. And essentially what they're asking is for appellate courts to backfill a missing element. And even looking at the U.S. Supreme Court's decision in Nader about if there is a missing element in the jury instructions and a person is asking for a new trial, and that's of course not what we're talking about here, we're talking about sentencing. But if a person is asking for a new trial, it's still the burden on the prosecutor to show that the missing element was harmless beyond a reasonable doubt. So to argue for a lesser, easier standard here doesn't make any sense, and it's not workable. This court, in determining whether a sentence for a group of people is cruel or unusual, does not parse out the facts of the offense for each of the people in that group of people. It didn't do so in Lyman, it didn't do so in Stovall, and it didn't do so in Parks. We could talk about the heinous facts of any murder, but it's not this court's job to determine the sufficiency of the evidence in determining whether a sentence is cruel or unusual punishment. We have other standards in sentencing, of course, rebuttable presumptions in Posey, a preponderance of the evidence standard in Hardy. But here, what we are talking about is a well-established test under Lorenzen for whether a sentence is cruel or unusual punishment. And for folks who were not found guilty of the most serious offense in Michigan, it is cruel or unusual punishment for this court to sentence them to die in prison.
Thank you all. The case will be submitted, and the court is adjourned.